So this bill here is just kind of a first step so that they can test some of these activities so next year we don't come at this without a full understanding. And other states have warrants or courts of orders of the courts for removal. But because their systems are so much different than ours, you just can't go and take them and put them on top of our system and make it work. Many of you know that I went up to Utah and looked at their court removal system, and we brought some of that language back, and after looking at it, realized it would not work. So this is a first step. It is not an overly complicated bill. There's been some questions about different portions of it and stuff like that. I feel comfortable that we're moving in the right direction, but if you don't, I understand, and if you have questions, I will stand for them. Thank you.
Thank you, Representative. Chair recognizes Representative Bolden.
Thank you, Mr. Chair. Would Mr. Allen stand a few questions?
I will yield.
He yields.
Thank you. So, Representative Allen, I do have a lot of questions and a lot of concerns. This DCS has been one of the major issues that I consistently hear about as a state legislator. Specifically, the removal of children from their homes has been a major issue I hear about. So I just want to make some clarification. So right now, there is a specific protocol in place to take a child. And there's due process. So you have the ability to go through the full-blown investigation. You interview the family, you interview the children, you interview any custodians, guardians, whoever may have information regarding making sure that the caseworker is making the appropriate decision. What I just heard you say is that this bill this amendment would remove the full-blown process to make it easier to take children from their homes. Is that correct?
Representative Allen.
Well, Mr. Chairman, Representative Bolden, you've kind of got, you're right and not right, because there are two circumstances in which kid can be removed. One is exigent circumstance. An example would be parents are passed out on the floor in drugs, the police come and do a well check, and the department moves that kid like that. That won't change, and that's protected in the Constitution already as an activity that we're allowed to do. But the part you're talking about is yes, there are other places where there's the ability to do a longer investigation with a lot more in depth, also with talking about recommendations for placement or permanency and that sort of stuff. We are going to take that part of the investigation and encourage the department to put it up towards a judge, which would be a lessening of the department's authority. In other words, they would be giving the process, some of the power of this process, away to the courts.
Representative Bolden.
Thank you, Mr. Chair. Representative Allen. So, essentially, as you mentioned, again, there's two circumstances, exigent circumstances. The child's in danger. If the department needs to take those kids, they already can. This bill doesn't change it. We're talking about if a child is not in imminent danger, this would still allow the department to remove a child, even though that child's not in imminent danger. And the reason why I'm asking that is because, as you know, you mentioned the courts, and a recent Ninth Circuit Court of Appeals had a decision which stated that you would need to obtain a warrant to remove a child if the child is not in danger. But what you're saying seems contradictory to what the court actually said. Could you please clarify that?
Representative Allen.
Mr. Chairman, Mr. Bolden, 180. We are moving in the direction of that court suit. This is the first step in assuring that we comply, even though that wasn't directed at us. But we can assume that the legal landscape, because of that decision and the 1983 decision, there is going to be changes in this, and we should get ahead of it. Very rare for us to get ahead of a DCS issue, but we're trying real hard. This is a very small step in that direction. My ultimate goal is to next year have the full nuts and bolts procedures with the department, with the courts, whether there'll be any extra expense, which at this point we think we can work our way around, and have a fuller discussion on it. But this is so that the department can step, and it's a may. They don't have to do this right now because we only want them to do it because they want to figure out how it works. That's what this does.
Thank you, Mr. Chair, Representative Allen. So how essentially you have this, this case in which, where you have the situation where you have a child in danger, you have a situation in which a child's not in danger. How long of a process is it between the time that DCS goes to the court says they obtain a warrant, the court says you can actually remove the child? Are we talking about hours, days? What's that timeline?
Representative Allen.
Thank you, Mr. Chairman, Mr. Boulding. I appreciate it because that's a good point. Right now, the process is the caseworker realizes, look, the kid's not in immediate danger. So we're going to do an investigation. We're going to talk to the neighbors. We're going to talk to the school. We're going to do the whole investigation. It then goes to the county attorney. The county attorney then makes a case for it, and it goes and it has a 3 to 5 day window. We want to make it so that once the department makes its decision through this process, you're talking about 3 to 5 hours. So we're no longer leaving a kid where, look, it's already been determined that the department thinks the kid should be removed. So there is risk. It's not immediate, but there is risk, and they've made that determination. Now they're turning to the courts in a much quicker manner and going, hey, look it, if there's the risk there and we can determine it through the court system where we have a second set of eyes, a second legal opinion, or whether it rises to the removal level, that's the way we'd like to do it.
Representative Bolden.
Mr. Chair, Representative Allen, I totally understand that and recognize that you have the 3 to 5 day process typically that it would take for you to remove a child that's not in immediate danger, and now this is moving from a 3 to 5 hour period it would take to remove a child that's not in immediate danger. And I recognize it is a razor thin line, right? We don't want a child in a home, in a situation if they're in danger, but we also want to respect the rights of due process of their parents and those children. And this leads along to my question. What's the process for parents to get back their children? Because my issue is this. If we take 3 hours to remove a child from a situation in which that child's really not in danger, will it take 6 months for this parent to get their child back? And that is a major problem an issue that I have with this bill, that we are taking 3 hours to remove a child, and we are potentially it could take parents a lot of time to get their kids back. So what is the process for parents to get their kids back if there's a mistake made in 3 to 5 hours?
Representative Allen.
Thank you, Mr. Chair, Mr. Boulding. And you share many of my concerns. These are separate issues in the sense where the removal process has its own standards, which now we are completely depending on these longer investigations on what the caseworker deems pertinent and what evaluation they make on the removal. This is just adding a little bit more surety at that end. The due process portion of it is not changing. That doesn't change one bit. What we're doing is we're making it so that the timeline and when a judge gives the order, he's saying, I agree, this child's at risk. Well, it makes no sense in saying, look at it, 3 to 5 more days at risk is a good thing. So this is actually getting more surety for families that have done nothing wrong or haven't raised to the point where a child should be removed. This is giving them a quicker ability actually to get due process.
Representative Bolden.
Thank you, Mr. Winiger. Mr. Allen. And essentially what I guess what I'm saying is maybe due process should be an issue within this bill because, again, we're changing the time frame from 3 to 5 days to 3 to 5 hours. And while you mentioned, due process is not an issue in this bill, what I'm suggesting is that it probably should be because, again, we are making a decision in we're talking about potentially 180 minutes we're making a decision about a child. do you have confidence that DCS could provide the information that they need to a judge in this 180 minutes? Do you have utmost confidence in DCS that they can actually do that?
Representative Allen.
Mr. Chairman, Representative Bolding, I don't exactly know how to answer that. I mean, the reason I'm doing this is because of lack of confidence in the way the system's working. I am trying to, through this amendment and through my efforts here, to bring a separate set of eyes onto this process. In other words, outside the department. So my confidence in the department is not why I'm doing this. I don't, you know, I think the department has improved greatly under its current management, but that management might not be there next year or 5 years from now. So what I'm doing is I'm putting the, 10 years from now. Sorry, Director. Stay as long as you like. But what I'm saying is I want to put a system in place that has longevity and stability outside of the department.
Representative Bowling.
Thank you, Mr. Chair and Representative Allen. So essentially, who would present information to the judge? Would it be DCS, or does the court have their own investigators that are going to do the decision? Because you're saying that you're taking the decision out of the hands of DCS, but to my knowledge, DCS would actually present the court's information, which means that they would have to gather that information, or does the judge have their own child safety team?
Representative Allen.
Thank you, Mr. Chair. Mr. Bowling, in this case, there's no change in procedure on that. That's who's making these presentations in the 3 to 5 days.
Representative Bowling.
Thank you, Mr. Chair and Mr. Allen. So again, that's what's the impetus of the question, that you have confidence in DCS, because DCS would be the agency presenting that information to the courts within 3 to 5 hours. And we know that there's already have been a number of issues with DCS. And I only have a couple more questions for you, just because I do think, yes, absolutely.
I'm going to treat that as a question, Mr. Chairman, Mr. Bowling. No, this process is not 3 to 5 hours. Whatever it takes to get the information that's needed for the judge, but then we're moving the decision-making process much quicker. So the investigation could still take many forms and collect many different types of information. We're just saying that once that information is collected, it can be presented to a judge and move more quickly, and before the child's removed. So it's just making it a little bit more surety that the department's making the right decision. The 3 to 5 hours is a hope on how long this process would take once we get good at it.
Representative Bowling.
And thank you, Mr. Chair and Mr. Allen. And this goes a little bit more into process, recognizing that we are hearing this floor amendment, which could change the DCS system, again, on the floor. So we have not had an opportunity for this to go through committee, for us to hear from stakeholders. Why are we hearing this for the first time on the floor, as opposed to the normal process to ensure that we have all of the information necessary? What's the immediate circumstances to hear it now if you, as you just mentioned, you're going to try to change it again next year? Why do we have to hear it right now and at this second?
Representative Allen.
Thank you, Mr. Chairman. Mr. Bowling, it's a good question, and what it is I think the department wants to, before it presents a comprehensive nuts and bolts process next year, they need to look at this process and be able to test a few things, and this is going to be very limited. They have no interest in going full bore at this until they figure a few things out, but this hasn't been done. This hasn't been done. So granted, this has a little bit of, hey, I've been working on this. This is the next logical step. We're going to have a much more comprehensive bill next year, but there is an element of let's trust the department to sort some of the issues out before before we get fully involved in the whole process, and then we make bad decisions that might even make the circumstances worse. So it is kind of a small step that gives the ability, the department the ability, that's why it's got may in there, the ability to test the waters on certain circumstances so that they can figure out what will work in this process.
Representative Bolden.
Thank you, Mr. Chair. I'd like to make a comment on the amendment.
Yes, proceed.
So this, I do have, the reason why I asked a lot of those questions primarily regarding this amendment is because, again, we are hearing it at the 11th hour in session. This has not had the opportunity for members to truly vet this and take this back to our constituents and stakeholders. And the idea that we want to test this amendment or test this system with people's kids, I take issue to that. You know, we can't test people's kids. You know, in 3 to 5 hours, we want to remove a child from their home, which could potentially affect the way in which that child's life outcomes are. That child may not be able to go back to their parents for months on end, and they find themselves in a system or a DCS system where we have kids sleeping on the floor, or kids that don't actually have the ability to make sure that they have the resources and the support systems that they need. The fact of the matter is, if there are larger issues that need to be fixed, we need to actually take the time to fix those issues and not try to put forth a last-minute amendment to fix a broader issue if the goal is to, you know, to achieve a fix next session. I mean, it doesn't make a lot of sense for me. As I mentioned, there are a number of members and constituents that I consistently hear who call the office, who email myself, I'm sure they email you, that have issues with the way DCS is operating, with the way that DCS is removing kids, and with the way that parents have the ability to get back their kids. There is no reason why I believe that we should look to expedite the process of taking kids who are not in immediate danger if we already have a process to take kids who are currently in danger. So that makes no circumstance. I don't understand the logic behind this bill, and one in which if the judge believes that the child is in imminent danger, then we wouldn't even need to go through this process because there's already a process in place. I recognize the sponsor of this amendment is trying to actually fix a system, and I can respect that, and I can respect all of the work that apparently he's put into it. But I do think that there needs to be a process in which the full body, we have the ability to vet this through committee, and we don't get this introduced at the last minute in a floor amendment. So with that, I respectfully ask my colleagues to not move this floor amendment. Thank you.
Chair recognizes Representative Rubalcaba. Please.
Thank you, Mr. Chair. Would Majority Leader Allen yield for a couple questions?
I will yield.
He yields.
Thank you, Mr. Allen. I do have a question. So I see this as a possible placeholder until we can get it right, come back with a bill in which we can address the issues that we're trying to address here. With that being said, would this put us in a situation where we would be violating the Fourth Amendment?
Representative Allen.
Mr. Chairman, Representative Rubalcaba, can you be more specific on how we would be violating the Fourth Amendment?
Representative Rubalcaba.
Mr. Chairman, Mr. Allen, yes. So the Fourth Amendment in regards to warrants is what I'm being more specific to, since this would not necessarily require us to utilize that process. So would we be in violation?
Keep going until you come up to that.
Mr.
Representative
Chairman,
Allen.
Representative Rubalcaba. Well, and actually, the word warrants has been thrown around because that's kind of what the public has kind of deemed this process. but it's really a court order. So it doesn't actually go to the Fourth Amendment because the person we're taking is not involved in a criminal activity or anything like that. This is an order of protection, basically. So it doesn't really fall under the Fourth Amendment. But I was going through my amendments, and I'm going, okay, is that putting troops in the house? Wait a minute, Fourth Amendment. So, no. So I hope that helps.
Representative Rubalcaba.
Thank you, Mr. Chair, Mr. Allen. And so with that being said, we would ideally like to go through the process of utilizing court orders or warrants. And so would you happen to know how many warrants or court orders we obtained this past year?
Sorry, I
Representative
got
Allen.
involved and I think we're going to hold the bill because of a language issue. So can I get you to, and I'll remain on the calendar because I think we have a language issue with the bill itself, the amendment.
Thank you. Members, give us just a second. Chair recognizes Representative Cobb.
Mr. Chairman, I move a substitute motion to my original motion that SB 1003 be retained on the calendar.
Members, you've heard the substitute motion of